My name is Ruth Ballantyne, and I am the convener of the Otago Women Lawyers Society, or OWLS as we are more commonly known. It is my absolute pleasure to welcome you here today to the 21st Annual New Zealand Law Foundation Ethel Benjamin Commemorative Address, which will be delivered by Professor Nicola Peart from the University of Otago Faculty of Law. In particular, I would like to extend a warm welcome to our previous speakers, Chief Justice Dame Shana Elias. That was a really nice touch. And Justice Susan Glazebrook, members of the Judiciary, Queen's Counsel, members of Parliament, the Mayor of Dunedin, Dave Cull, councillors, members of the profession and fellow OWLS, especially our much cherished life members, representatives from the New Zealand Law Foundation and the New Zealand Law Society, university colleagues, especially the Vice-Chancellor of the University of Otago, Harleen Hain, Faculty of Law colleagues, especially the Dean of Law, Professor Mark Hennigan, and Deputy Dean Associate Professor Jessica Palmer, and perhaps most importantly, Professor Peart's husband David and son Simon, who are over there. I would also like to acknowledge the large number of people who are unable to be here this afternoon, including Professor Peart's daughter Emma, who is currently overseas. As many of you know, this address honours the life and career of Ethel Benjamin, the first woman to be admitted to the bar in New Zealand and the first woman in the British Empire to appear as counsel in court. She was also, of course, as Mark Hennigan would say, a fine Otago graduate. Over the past 21 years, OWLS, with the generous support of the New Zealand Law Foundation, has invited outstanding women of the law to deliver this address. The primary objectives of the address are to honour and preserve the pioneering spirit possessed by Ethel Benjamin, to encourage education and achievement in the women of today, and to stimulate debate about issues affecting social justice and gender. This address has been presented by the highest calibre of speakers, and today is no exception. Our speaker this year, like those of the past, is a woman with a most impressive legal career and embodies a pioneering spirit that Ethel would be proud of. To most of you, Professor Peart needs no introduction. She is a formidable academic with a stellar national and international reputation and excels as both a researcher and a teacher. She has taught property law, wills and trust, and advanced family property at the Faculty of Law for the past 30 years, meaning she has probably taught a large number of the lawyers in the room today. Professor Peart has an extremely impressive research portfolio and has authored and co-authored a vast number of academic texts, including 42 book chapters and 55 journal articles that all make a significant contribution to the law of trusts, family property, succession, and medical law. She also regularly speaks at New Zealand Law Society conferences and other conferences around the world. Professor Peart is a long-time supporter of OWLS and is one of our much-loved wise OWLS, providing mentoring and support for many of us over the years. She has also been described recently by our student branch of OWLS, known as the Owlettes, if you please, as both the, quote, matriarch of the law faculty and as the Dutch grandmother they never had. Every Ethel Benjamin address is special, but this year's address is particularly so because this year marks 120 years since Ethel Benjamin's trailblazing admission to the bar. What better person to mark this occasion on the 21st birthday of the address, no less, than Professor Peart, not just for her immense academic achievement and numerous personal attributes, but because in 2006 she became the first female Professor of Law at the University of Otago. A mere 109 years since Ethel Benjamin graduated from the same institution. Professor Peart's pioneering spirit, hard work, determination, and support of her fellow women has paved the way for many more talented women to reach this pinnacle of academic achievement, both now and in the future. It is an understatement to say that Ethel would be proud. Without further ado, it is an honour and a privilege to introduce my colleague and friend, Professor Nicola Peart, to deliver her address entitled Property Rights on Death, Policies in Conflict.
Convener, thank you very, very much to Ruth Ballantyne and to Kim. Where's Kim? She's lurking there somewhere. Anyway, Kimberly Jarvis, who cornered me at lunch a year ago and said, would I give the Ethel Benjamin address? And I have to say at that point, I said, you have to be joking. And it did take me a little while to be convinced that this is what I should do. But it is an honour and a privilege to be invited to give this address, even if it is somewhat daunting, particularly given those who have gone before me, at least two of whom are in this audience today. Thank you all very much for coming. It is really quite amazing to see how many of you are here, and I'm particularly flattered by the large number of you who have travelled from afar. I feel very honoured by your presence. I'd also like to take this opportunity to thank Kyla Mullen, who assisted me with the presentation and the address, and to Ruth Ballantyne, who now really knows how technologically incompetent I am. These PowerPoint slides wouldn't have existed but for Ruth's assistance. Okay, so, there we go, sorry. Ethel Benjamin was admitted on the 4th of May 1897 by Justice Williams as a barrister and solicitor of the Supreme Court. And as Ruth said, she was the first person to be admitted to legal practice in New Zealand. Now, much has changed in the past 120 years, particularly in regard to women's property rights. And my focus in this address is on property rights on death, both of women and of men. I've chosen this topic because our current law has been developed in piecemeal fashion over the past 120 years and is underpinned by conflicting policies which make the law uncertain and unpredictable. Now, that is a problem for all of us, because if there's one certainty in life, it is that we all die. And what happens to our property is something that usually concerns us, and it certainly concerns those that we leave behind. I'd like to begin by going back to the first 25 years of Ethel's life, because those were years of enormous social change in New Zealand and legislative reform. Ethel was born on the 19th of January 1875, the eldest of 10 children. Her parents, Lizzie Marks and Henry Benjamin, were immigrants from Australia and England, and they arrived in Dunedin in the late 1860s. Dunedin was a prosperous city, as it still is, commercial capital of New Zealand, that's perhaps a little more of a stretch now, and they valued culture and education. Otago Boys High School and Otago Girls High School were established in 1863 and 1871, respectively. The university opened its doors in 1869. Now, when Lizzie and Henry married in 1873, the principle of matrimonial unity applied. Husband and wife were one person in the eyes of the law, represented by the husband. The wife's legal existence was suspended for the duration of her marriage. She had no independent capacity to enter into legal relations, and she lived under her husband's coverture or protection. He acquired ownership of all of her chattels and money, and he controlled and managed all her interests in land and retained any income derived from it. His duty was to provide her with necessaries. John Stuart Mill, writing in 1869, characterized her position as akin to slavery. On a husband's death, his widow would regain her independent capacity, but she had no power of or rather, she had no protection against disinheritance. Robert Stout, a fiercely free-thinking Scot who had immigrated to New Zealand in 1864, also settled in Dunedin. and he was an articled clerk in the law firm of Downey Stewart in 1867, 150 years ago. He must have been one of the first articled clerks that Downey Stewart took on, because they're just celebrating their 150th anniversary this year. He was called to the bar in 1871, and the day after he was admitted to the bar, he enrolled at Otago University as the first student, taking mental and moral philosophy and political economy. Law teaching started in 1873, and he was the first law lecturer. Stout was passionate about education and a strong proponent of equal rights for men and women. In 1884, that went too quickly, sorry. In 1884, when he was Premier of New Zealand, he moved the adoption of the Married Women's Property Act to end the unfairness of matrimonial unity. His opponents said that the bill was socialist, but he said, no, it's the opposite. It's individualism, which tends to give equal rights to both sexes, and a state of society based on any other doctrine than equal rights will never last long without doing evil to both parties. Stout didn't share his fellow parliamentarians' concerns that the act would cause social revolution, but it was radical and subsequently was hailed as an even greater triumph for women than gaining the vote. But it was of little value to women who had no property and had no means of acquiring it. It treated spouses as strangers. Unless a spouse had contributed financially to the property of the other spouse, there was no right to share in the property of the other spouse. Ethel's mother, Lizzie, for example, spent most of her married life bearing and caring for children. She died in 1896 at the age of 47, when her youngest child was only 2 years old and Ethel was 21 in her final year of her law degree. It was Henry who acquired the family's property, and he was free to deal with it as he pleased, including leaving it to whomever he wanted by will. Testamentary freedom was absolute in those days, because testamentary freedom was regarded as one of the most valuable of the rights incidental to property. It allowed testators to reward dutiful and meritorious conduct, and it was therefore a useful auxiliary to parental authority. Just remember that, Simon. The carrot and the stick. But in the same judgment where these quotes come from, a case called Banks and Goodfellow, which all the students back there should know, a moral responsibility of no ordinary importance attached to the exercise of this freedom. It was to provide for the nearest in kindred and for those whom in life had been the objects of the testator's affection. Now, that moral responsibility was not always observed. Wives and children were disinherited and left destitute. That was the reality that Ethel Benjamin encountered when she started legal practice here in Dunedin in 1897. And there she is, on her own, in the middle, the sole female practitioner at the opening of the law courts in 1902. I'd like to think that when the new court, when the old court building is reopened in February next year, we might have another such photo, and what a different picture that will paint. Now, Ethel often acted for deserted wives, and she was the honorary solicitor for the Society for the Protection of Women and Children. Testamentary abuse was quite widespread, it seems, in those days. Stories abound. And fresh from winning the suffrage in 1893, the women's movement turned its attention to limiting testamentary freedom. It characterized testamentary freedom not as a power to provide, but as a power to disinherit. There was also at that time a change in the liberal ideas, away from the pure individualism that Stout had propounded, towards a more humanist and interventionist state. Even Sir Robert Stout became aware of the vulnerability of women in the home and in the workplace, and he made limiting testamentary freedom an election issue in 1893. Now, it's be fair to say that he was strongly encouraged by his wife, Anna Logan. Anna Logan, or Anna Stout, was born in Dunedin in 1858, the daughter of Scottish immigrants. The Scots really had a profound effect here. It's amazing. Stout was a regular visitor to the Logan household, and he married Anna in 1876 when she was just 18 years old. Like her parents and her husband, she believed in women having equal rights with men and the freedom to develop their intellectual ability to its fullest potential. But with 6 children and travelling between Dunedin and Wellington to support her husband's political career, she was rather limited in her ability to give public voice to her beliefs. But that changed in the 1890s. She joined the suffragists and she became one of the new women. In 1896, as Vice President of the newly formed National Council of Women of New Zealand, Lady Anna Stout moved a motion at the Council's first meeting that every man owning property and having a wife, or that won't be bad, or a wife and children, should be compelled to make provision for them out of his property. And her proposal was to limit testamentary power by giving the widows 1/3 and the children another 1/3. Just a few months later, how did that go so quickly? If I press it too much, it skips. Just a few months later, Stout introduced a bill along exactly those lines. But his fellow MPs did not support such a radical limitation on testamentary freedom. It might reward the undeserving, and as for leaving a widow 1/3 of the estate, that was simply unacceptable. She might end up supporting the husband's successor if she remarried. So Stout retired from politics in 1898, and the baton was then taken up by Robert McNabb, another lawyer and farmer from Southland this time, and he continued with Stout's idea of limiting testamentary freedom. But rather than limiting testamentary power to a portion of the estate, his suggestion was to give the courts the discretion to override wills when the testator had failed to make due provision for the maintenance and support of the testator's wife, husband, or children. So what was due provision? Well, McNabb and others who had supported Stout's bills favoured a liberal approach to the assessment of maintenance and support, taking account of the applicant's station in life. But the majority thought it should be confined to the necessaries of life, an extension of the Destitute Persons Act to prevent people from becoming dependent on the state. Realising that the liberal approach would not gain majority support, McNabb introduced his final bill by linking it to the Destitute Persons Act. And he then said, before you dispose of your property, first carry out your obligations. First see that you do not leave any person destitute. First see that any person who is at present dependent on you for his or her support and maintenance is not left on the state for support. Now, the final wording that was given to this power was slightly different. And it reads that if the testator has failed to make adequate provision for the proper maintenance and support of his or her spouse or children, the court has the power to make orders against the estate. Now, that slight change in wording ended up being very influential, as I'll explain shortly. But it also indicated that the statute meant different things to different people. Some thought it was essentially a maintenance provision, whereas others saw it as having a rather wider role. Whatever its meaning, it was hailed as one of the success stories of the women's movement, and it was one of New Zealand's first social exports. This legislation was copied in Australia, then in Canada, and finally in 1938 in England. Given Ethel's concern for deserted wives and children, she would have welcomed the Act, though it seems that she never took a case under it. And so the 20th century begins with more or less consistent policies on family property rights. Spouses had no entitlement to share in each other's property, either on death or on divorce. They were free to dispose of their property during their lifetime and on death. While alive, husbands had a duty to provide the necessaries to their wives and children. And on death, there was some ambiguity as to what their support obligations were. Was it limited to providing necessaries of life, or did it go beyond that? And so we go to the question of what is meant by adequate provision. And there was division amongst the judges. Justice Edwards, pictured here, represents the conservative view. And that may have been a reflection of his upbringing. He grew up in harsh and straitened family circumstances on a remote farm on the Otago Peninsula. He was apparently also a very controversial judge. He was arrogant, ill-tempered, and struck a strong dislike to some of the council appearing before him. In fact, I think they managed eventually to get rid of him. I can see Shana Elias is nodding, she knows that. He was clearly well known and his reputation has lasted. Anyway, his view was that Testator's Family Maintenance Act should benefit only those who would have had a claim during the lifetime of the testator. In other words, the widow and dependent or destitute children. The widow had a first claim, but she did not need to be destitute. On the other hand, her husband's duty was merely to provide necessaries. There was no obligation, and it did not extend to providing her with a fund which she could then give to others at her death. So he said no lump sum payments for widows and awards of periodic maintenance should be limited to her widowhood. In other words, if she remarried, she lost it. In terms of adult children, he was similarly conservative. He accepted that the legislation imposed no age limit and that so adult children were eligible. But he said that as the father had no legal duty to support his adult children, he thought it would take a very strong case to justify an order in their favour. Contrast that to Chief Justice Stout. This was Sir Robert Stout, who had in 1898 been appointed as the Chief Justice. He took a more liberal view, as you might expect, because that was, of course, also his view when he was putting forward the legislation initially. In regard to widows, he said that adequate provision meant that they should be able to support themselves in accordance with their station in life. She should be allowed to live her life in the style to which she had been accustomed when she was married. And if that was a poor style and there was enough money, she should get a better style. He had no problem saying that the Act allowed for lump sum awards, didn't agree with Justice Edwards at all. As for adult children, he did not think they needed to be destitute. He took a very dim view of testators who left their property away from their children. But he accepted that he was constrained to intervening only if there was a need for maintenance and that he couldn't do what he thought was fair. In 1906, the statute was amended to allow for lump sum awards. And that persuaded Justice Edwards in 1909 to formulate a test for intervention which referred to the testator's moral duty rather than his legal duty. And that test is a test we still largely use today. It is the duty of the court, so Justice Edwards said in 1909, so far as possible, to place itself in all respects in the position of the testator and to consider whether or not, having regard to all existing facts and surrounding circumstances, the testator has been guilty of a manifest breach of that moral duty which a just but not loving husband or father love that, owes towards his wife or towards his children, as the case may be. You don't need to love them. Okay, that was 1909. And despite that sort of broader view, until the 1960s, the Act remained very much a maintenance provision. Financial need was still seen as important and relevant, but it was relative to the applicant's station in life, their age, their health, their potential future needs. It was moderated by their conduct. If they'd behaved badly, they might lose out. The size of the estate and the strength of competing moral claims. For widows, it meant that they should be provided with sufficient means to live with comfort and without pecuniary anxiety. Awards, though, still took the form of periodic payments limited to the widowhood, because, and I quote, this is a case in 1965, a husband has such an interest in his wife's widowhood as to make it lawful for him to restrain her from making a second marriage by making a condition that on such remarriage, any provision he may have made for her shall cease. It wasn't until the 1970s that widows began receiving capital awards and that provision was no longer limited to their widowhood. Widowers, their claims were treated very sparingly because, frankly, the courts were rather suspicious of a man who was dependent on his wife. But if an order was justified, there was no reason to limit it to periodic payments, because a husband might well expect that if his wife remarries, she will be supported by her second husband, while a wife should contemplate that if her husband remarries, he will have to support his second wife. This gendered view of spousal roles in the 60s and their economic value of their respective contributions came under increasing pressure from the 1960s onwards. And we then see a new change. Marriage is now seen much more as a partnership to which both spouses contribute, albeit in different ways. And there was a growing appreciation of the economic value of domestic work. So, as Lord Simon of Glaisdale put it in 1964, and I have to say I love this quote, the cockbird can feather his nest precisely because he is not required to spend most of his time sitting in it. I think it's such a wonderful quote. I have used it so often. But I did not know that Lord Simon had a patched eye. I only just discovered that. Woo, sorry. So, 1963, Parliament in New Zealand stepped in to pass the Matrimonial Property Act. And that was the first time that the court was given the power to redistribute property as between spouses solely on the basis that they'd actually been married, based on the contributions that each spouse had made to the property in question. Monetary and non-monetary contributions were relevant, but in practice, only financial contributions carried rather more weight. Wives really received an equal share of the matrimonial property. On death, there was the added complication of what to do about the inheritance. The Act was silent on that. Should a widow be entitled to take her share under the Matrimonial Property Act as well as keep her inheritance? or should the matrimonial property award be reduced or even declined on the grounds that she was getting as much or perhaps even more in the way of inheritance from her late husband? And what about the competition with family protection claims? Should the matrimonial property award take priority over family protection claims, which was the Testator's Family Maintenance Act and since renamed the Family Protection Act? Should the matrimonial property award take priority over the family protection claims, or should it be dealt with altogether? Now, the central problem in this question was the uncertain status of matrimonial property awards under the 1963 Act. It was not a property entitlement because the applicant had no rights to anything until and if the court exercised their discretion in her favour or in his favour. So they couldn't say, I'm taking what is mine, until the court had made that order. So that was a problem. There was also another problem with the Matrimonial Property Act, and that was that the courts were not making awards recognising the contributions, particularly of women, in relation to property, particularly non-domestic property, property acquired by the husband, say businesses, farms and the like. They were not seen as contributing quite so well to those properties, and hence they weren't getting a fair share. That persuaded Parliament to pass a new statute, which was the Matrimonial Property Act of 1976. And that act effectively still applies today. It works on the basis that spouses contribute to a partnership, and they are presumed to be contributing equally, and hence they should be sharing equally in the proceeds of that partnership. Now, that particular act effectively does give spouses a property entitlement. They're entitled to half of the property, subject to some limited exceptions. But the 1976 Act did not apply on death because of the complication of succession law. Parliament felt they needed to pass this legislation, and separation and divorce was more urgent than dealing with death. So they assured everybody that they would deal with the matrimonial property rights on death soon after they'd introduced this act, but in fact it would be another 25 years before they did. So that left surviving spouses in a rather unenviable position of still being dependent on the court's discretion under the Matrimonial Property Act of 1963, the old one, whereas separated spouses had the benefit of being able to rely on the presumption of equal sharing. So it was better to separate than to die, frankly. To make matters worse, we have the Family Protection Act. And why it became worse is that under the Family Protection Act, the courts were becoming increasingly liberal towards claims by adult children. They said that the wording of adequate provision for the proper maintenance and support meant that something more than just maintenance was required for adult children. Moral and ethical considerations applied as well. And that meant that disinheriting adult children or leaving them less than their fair share could be seen as a breach of moral duty. It was important to recognize the parent-child relationship, the family bond, regardless of financial need. That was especially so if the deceased had remarried and the children were from a prior relationship. The risk was that the property from the initial relationship would then pass to the next relationship, and the children from the prior relationship would lose out. So in the 80s and 90s, surviving spouses were at the mercy of the courts, both in terms of their matrimonial property rights and in family protection claims. Their rights were uncertain and unpredictable. Recognize her? This is a photograph of four people who many of you will probably recognize. In 1988, a ministerial working group was appointed to advise on matrimonial property and family protection. The Chief Legal Advisor of the Department of Justice convened the working group, and its consultants included 2 law commissioners, Sian Elias, QC, as she then was, now the Chief Justice, and Margaret Wilson, who later became the Attorney General and the Speaker of the House and the Foundation Dean of the Law Faculty at Waikato University. The gentleman at the bottom, on the left, is Warwick Gendel, then a barrister and subsequently a High Court judge, and Bill Atkin, then a senior lecturer and now Professor of Law at Victoria University of Wellington. This group made 3 recommendations in relation to matrimonial property and family protection. The first was that the equal sharing regime that applied on separation should also apply on death. Surviving spouses should be no worse off than spouses whose marriage had ended on separation. They should be entitled to take what is rightfully their own property, and that entitlement should take precedence over any inheritance. But if the surviving spouses chose to claim their matrimonial property entitlement, then they would lose their inheritance. So you couldn't have both. Secondly, they said that the estate of the deceased spouse should have no right to apply for equal division, because the contents test on death is not between 2 spouses, but between the surviving spouse and the beneficiaries of the estate. And clearly the beneficiaries of the estate were simply receiving effectively a gift and were therefore less deserving. The third recommendation related to the Family Protection Act. The working group report took a dim view of the kind of orders that were being made simply to recognize the family bond as between parent and child. They did not believe that the Family Protection Act should be rewarding that sort of connection, but should be focusing on financial need. Now, nothing was actually done to implement those recommendations in that report. And a few years later, the Law Commission began a review of the whole of the law of succession. That review was led by Law Commissioner Richard Sutton, my former colleague, to whom I am indebted for sparking my interest in succession law. The Law Commission was critical of the state of the law. It saw no reason, in relation to family protection claims, why obligations on death should be any different from lifetime obligations. Its aim was to repeal all statutes dealing with succession law, including the Matrimonial Property Act of 1963 and the Family Protection Act, and replace them with a new single Succession Act that aligned claims against estates with lifetime rights and obligations. Its proposal was that in the first place, much like the working group, the New Zealand Law Commission proposed surviving spouses and de facto partners should be given a choice of applying for division of partnership property on the same basis as separated spouses, or take their inheritance. So again, that split. They either inherited or they took their share of the relationship property. In contrast to the 1988 working group, they believed that the estate should also be entitled to bring a division claim. And thirdly, they said that spouses and partners and dependent children should be entitled to bring a support claim, but that adult children should only be entitled to claim if they were in real financial need. Now, those recommendations no action was taken there either. Perhaps the restriction on adult children's claims may have been too radical. That certainly appears to have been the view of the Court of Appeal when it dealt with a family protection claim in 2000 by a wealthy daughter against her mother's estate. The President of the Court of Appeal then, Sir Ivor Richardson, explained that support is an additional and wider term than maintenance. Support is used in its wider dictionary sense of sustaining, providing comfort. a child's path through life is supported not simply by financial provision to meet economic needs and contingencies, but also by recognition of belonging to the family and of having been an important part of the overall life of the deceased. Now, the applicant in that case had assets of around $1 million. Her sister had about $80,000 and was in financial need. The court nonetheless increased the award that was given to the wealthy daughter to recognize the importance of her in the family. And so we enter the 21st century amidst a sea of conflicting policies and principles. We have uncertain matrimonial property rights for spouses because they're still dependent on the 1963 Act. We have a very liberal approach to adult children under the Family Protection Act, and testamentary freedom is effectively a myth. Now, Parliament was aware that property rights of spouses and partners on death were a mess, and in 2001, the Honourable Margaret Wilson, then the Attorney General, introduced an amendment to the Matrimonial Property Act of 1976 to extend the equal sharing regime to relationships ending on death and to de facto partners who had lived together for 3 or more years. The amended act was then renamed the Property Relationships Act to reflect the fact that we now included de facto relationships as well. The new death provisions were taken mostly from the 1988 Working Group report rather than the New Zealand Law Commission proposal. And again, we see that stark choice for surviving spouses or partners. They have a choice of choosing option A, and it's called option A in the Act, of taking their share of the relationship property. And if they do, they forfeit their inheritance. Or they may choose to take their inheritance and not take their share of the relationship property. Now, the 1976 Act does clarify the status of the relationship property claim on death because it means that when a spouse claims their share, they are taking what is effectively their entitlement to property. And therefore, it takes priority over any succession claims. But the effect of electing a property division on the spouse's succession rights blurs the distinction between matrimonial property law or relationship property law and succession law. Why should the surviving spouse or partner lose their inheritance because they've claimed what is rightfully their own property? As a matter of principle, I don't think it makes any sense. There's a further blurring in the Act. The estate has no right to apply for a division of relationship property. They require leave from the court, which may be granted only if serious injustice would otherwise result. Now, leave is generally granted if a meritorious claim would otherwise fail, such as a family protection claim by children of a former relationship. Now, that may avoid any serious injustice, a fairly pragmatic outcome, but as a matter of principle, restricting the estate from bringing a claim is problematic. It leaves the surviving spouse with property that in fact belongs to the deceased, potentially at the expense of those whom the deceased wanted to benefit. But more fundamentally, the Property Relationships Act treats spouses and partners differently on death as compared to separation, and yet they're in the same statute, subject apparently to the same principles. But on separation, the policy objective is equality as between the parties. They should share equally in the relationship property. On death, the policy objective is that the surviving spouse should be no worse off. Inequality between the surviving spouse and the deceased spouse is tolerated, even preferred. If death and separation are to be treated differently, then the death provisions have no place in a statute designed to deal with division on equality. So there are conflicting policies within the PRA, the Property Relationships Act itself, as to how spouses and partners are treated on separation as compared to death. There are also conflicting policies in regard to support obligations to adult children. Whereas support during a parent's lifetime is to provide for a child's financial needs until they turn 19, on death, the obligation is to recognise the child as an important member of the family, regardless of financial need. Finally, I turn briefly to the Wills Act. Its aim is to give better effect to testamentary wishes. And to that end, it has simplified the formal requirements for making a will. It has also given the court the power to validate informal wills that do not comply with the formal requirements, such as signing and witnessing, but where the court is satisfied that the informal will expresses the testamentary wishes of the deceased. That document that you see on the screen is an example of an informal will that was validated by the courts as representing the deceased wishes of Betty Williams. No witnesses, nothing. So now that power has been used on many occasions over the past 10 years. But there are also other provisions in the Act aimed at giving better effect to testamentary wishes. Now that aim of giving better effect to testamentary wishes sits very uncomfortably alongside the Property Relationships Act and the Family Protection Act, both of which override testamentary wishes. So little wonder then that property owners seek refuge in the law of trusts, though through trusts, they are able to control the destiny of their property and know that their arrangements are safe from challenge, at least under the Family Protection Act. So to conclude then, in 2016, the New Zealand Law Commission started a review of the Property Relationships Act, and its terms of reference include the death provisions in the Act, as well as all other aspects of the Property Relationships Act. The discussion paper that is going to be available for consultation is going to be released next month. They will want feedback, I think, by February, and they will be reporting back to the Minister with their final recommendations in November 2018. Now, this review and the public consultation, which is soon to start, provides an opportunity to resolve some of the conflicting policies. It cannot address the Family Protection Act, but it can resolve the conflicting policies under the Property Relationships Act. My view is that we should accept that death is different from separation, that property rights on death are best regulated through succession law, covering both the relationship property entitlement of spouses as well as the deceased's support obligations. And as a first step, I hope that the Law Commission will recommend that the Property Relationships Act be left to deal with property rights on separation, and that they will propose a separate statute for relationship property rights on death, to which perhaps at a later stage the support obligations could be added. In my view, that would provide a more coherent approach to property rights on death and remove at least some of the current conflict in policies governing relationship property law and succession law. Thank you.
Thank you, Professor Peart. My name is Shane Milne and I'm the Deputy Convener of the Otago Women Lawyers Society. We have a large number of guests attending here today, which is a testament to Professor Peart and the high regard she is held in by us all in the legal profession and the community as a whole. I stand here today proud to be commemorating Ethel Benjamin. Professor Peart has presented us with a thought-provoking and insightful address. How times have changed since Ethel Benjamin was admitted to the bar. I wonder what she would have to say about the progress we've made. Professor Peart has highlighted to us in her address how the evolution of social norms and attitudes can shape the law. It was particularly interesting to hear how different things were in times gone by. From the 19th century, where, as Professor Peart put it, a woman's legal existence was suspended for the duration of the marriage. It is difficult to imagine such times in this day and age. To the 20th century, where the focus shifted to treating marriage as more of a partnership. To the 21st century today, where we have an equal sharing regime which extends beyond marriage. Professor Peart, you have presented us with a thoroughly engaging address and commemorated Ethel Benjamin by reminding us of the way society used to be and just how far we've come. We thank you for providing us with the privilege of hearing you speak today and would like to show you our appreciation for being the 21st speaker of the annual New Zealand Law Foundation Commemorative Ethel Benjamin address by presenting you with this brooch.
I will enjoy wearing it.
Good, well done. Thank you again, Professor Peart. I would also like to thank our amazing sponsors without whom this annual event would not be possible. The New Zealand Law Foundation, the University of Otago Faculty of Law and the Williams Trust. Thank you also to our incredible convener of OWLS, Ruth Ballantyne, for pulling all of this together and the rest of our OWLS committee. A huge thank you to the Dunedin Public Art Gallery, Inspired Pantry Catering and the University of Otago AV team for your continued support of OWLS. I would now like to invite Dr. Andrew Butler, Chair of the New Zealand Law Foundation, to say a few words.
Kia ora tātou, Chief Justice, members of the Judiciary, distinguished guests. It's a privilege for me to be able to be here on behalf of the Law Foundation for this very special event, special in two ways. I'll talk about the second way in a moment. But the first way is to commemorate a very important event in our life, which is the 21st annual address given today by you, Nicola. We're very proud of our association with the address. We've been funding it right from the beginning, and we've had some wonderful speakers in the past. And Nicola, you absolutely, as expected, fit right at the very top of the memorable addresses. Thank you so much. I want, if I can, please just pay tribute to the Otago Women's Lawyers Society and the sterling work that you do, and particularly in relation to this address. I just wanted to note the good relationship that our foundation has with this city. So we're a relatively small charity, and the idea of our charity is to support work in the legal area that make sure that their projects are undertaken that support independent research of legal significance, independent of political or commercial interest. And what we're trying to do is to work to improve the understanding of the law, to try and build capability, to strengthen legal professional practice, and to assist overall better development of quality law and quality policy. We currently have funding in this city of over $1.5 million, and I thought you'd be interested to know the sort of work that in this city we're helping to fund. So, for example, at the moment, the Donald Beasley Institute is undertaking a piece of work in relation to best evidenced best practice. There's a project in this city that we're helping fund through the university, combined effort between the faculties of law, philosophy and computer science, looking at artificial intelligence in the law. We're helping the law faculty and the Children Issues Centre evaluate the effectiveness of the family law reforms that are underway. The Legal Issues Centre, we've helped them with looking at work on delays in the civil justice system. Acclaim Otago, which has been undertaking some really interesting work in relation to the operation of the ACC system. The Bioethics Centre, Future of Selective Reproduction and Genetic Testing. Animal Welfare Law Research, one of the more recent projects that we've helped get underway. And then, of course, the really good work that's been undertaken by NZLE, so the New Zealand Legal Information Institute. If you tot up all of those projects that we're helping fund at the moment, that's $1.5 million worth of work. And I did check with Linda beforehand to see, in terms of the money that we have given to the faculty and to the law faculty and other offshoots, so to speak, of the university, and it's just shy of $7 million. So I just wanted to publicly acknowledge what a great contributor this city has been, and the institutions within this city have been, to the progression of legal thought in this city. And I think your address really emphasised really very well, subtly as always, Nicola, the great contribution that this city has to offer. If I can, so the first thing I'd wanted to do is just acknowledge the Ethel Benjamin address, but I just also wanted, if I could, just for one personal moment, Nicola, just talk about you. I think it's very appropriate indeed, that the 21st address is an address undertaken by Nicola, because if you think about the 21st, something that's the 21st, you're thinking somebody young. And if there's one word that I would always use to describe Nicola Peart, is she is ever young. Nicola, you were one of the first academics I met when I came to New Zealand at the very tender age. I just turned 23 by a week when I arrived to be an academic here, and you were just one of the most wonderful people who took me, as you do with so many other people, under your wing, showed me some of the ropes, things to avoid. Your joie de vivre is so well known. You're infectious, you're fun. But as you showed today in this particular address, all of that's taken as a given. But it's your rigor, your academic rigor, your intellect, but also the way in which you care about the issues. It's not just academic for the sake of being academic. It's academic because the work that you can do will make a real difference to the lives of real New Zealanders. I thought the way you presented that talk today was just terrific, picking up on the contributions that people have made in this area over time. And if I can say on behalf of the audience here, that what was unspoken was your contribution in this particular area, but we should acknowledge it publicly here. Your contribution in this field has been enormous, and I want to thank you so much for it. So, ladies and gentlemen, thank you so much for coming along today, and thank you, Owls, for the opportunity to allow us to say a few words on a very, very special occasion. Thank you very much, ladies and gentlemen.
Thank you, Andrew. Once again, a big thank you to the New Zealand Law Foundation for making this event possible, and to the incredible Professor Peart for her wonderful address. That brings the 21st Annual New Zealand Law Foundation Commemorative Ethel Benjamin address to a close. Please join us for light refreshments upstairs in the ODT gallery. Thank you.